This is one of the most important issues. The irregularities of the PhilHealth legal sector. It is stated in Section 17 of Republic Act number 7875 as amended that the PhilHealth has quasi-judicial power in order to carry out its tasks more effectively by conducting investigations or the determination of a question, controversy, complaint, or unresolved grievance brought to its attention and render decisions, orders, or resolutions thereon. As a penalty, PhilHealth may impose a suspension, revocation, or restoration of the accreditation of a healthcare provider or the right to benefits of a member and or impose fines. Now, there is prolonged inaction on pending cases, Mr. President. Based on the submissions of PhilHealth to the committee, for the period of 2000 to 2019, 9 years, there are 7,452 pending cases against healthcare institutions, which involve both fraudulent and non-fraudulent offenses. However, for the same period, only 5,327 was decided on by the agency. This means that for a span of 19 years, only 71% of cases was acted upon relative to cases against healthcare institutions. As regard cases against healthcare professionals for the period of these 19 years, there are 4,792 pending cases in the agency, which comprises 1,968 fraudulent offenses and 2,824 non-fraudulent offenses. However, based on the same document submitted by PhilHealth to the committee, only 45.97% of the pending cases against healthcare professionals was disposed by the agency in a span of 19 years. To scrutinize it further, out of 1,968 fraudulent cases, only 745 was decided upon by PhilHealth, which is equivalent to a measly 37.85% of cases disposed. While for the non-fraudulent offenses against healthcare professionals, out of the 2,824 pending cases, only 1,458 cases were decided upon by the agency, which translates to 51.62% case disposable or disposal rate for a period of 19 years. Likewise, during the 18 August 2020 hearing, yours truly, this representation, raised an issue on wholesale amnesty brought to the Phil Board or the PhilHealth Board. It was admitted by the resource person that indeed it was done by the board. But as to the frequency, no clear answer was given. This was how the discussion went. Allow me to read some of the portions of the discussion. The chairperson. Now, I received information that on May 14, Attorney Del Rosario, the Protest and Appeals Review Department of PARD, under the legal sector headed by Attorney Del Rosario, presented the PhilHealth Board the appealed claims for 2011 to 2019 worth 3.9 billion for wholesale amnesty. The PhilHealth Board approved the amnesty for the appealed claims with were only worth 668 million. Now, these are the questions. First, since the start of the operations of PhilHealth, how many times has the board declared wholesale amnesty? Mr. Del Rosario did not answer. So the chairperson said, perhaps Secretary Duque can answer the original question. How many times has the board acted on wholesale amnesty? You were there for a long time, Secretary Duque, as head, as DOH Secretary, PhilHealth. Did you know how many times they declared wholesale amnesty? Secretary Duque, as I have said, Mr. President, I do not have a recollection of how many times we as alleged that there was a wholesale grant of amnesty. But I will look into it, Mr. President, Mr. Senate President, rest assured. Yun ang mga ayaw natin na sagot no? Hindi, titignan po namin. Sasubmit namin. Anyway, I said, so you're saying that this is the first time you have been there since 2000 during the time of former President Macapagal Arroyo, Secretary Duque. If I may, with your permission, Mr. Senate President, I would like to direct that to Corporate Secretary who holds the records, Attorney Jonathan Mangawang. Attorney Mangawang, how many times have you declared nasa? Sagot niya. I came in as Corporate Secretary only 2017. So from 2017 onwards, Mr. President, I can attest that this is the first time that wala tayo nakuha maganda sagot no? Although, this representation has no issue on the fact that the board has exercised the same. What concerns me is the fact that these cases submitted for wholesale amnesty have been pending with the PARD, or Protest Appeal Review Department, for 9 years. Such failure to act and gross neglect of duty have resulted to the financial prejudice of PhilHealth and the healthcare providers, as the case may be. While SBP for Legal Sector Rodolfo de Rosario projects that he is against fraud, it seems that the records prove otherwise, considering that a lot of cases are still pending or enacted upon by the agency. Another topic relative to the irregularities in the PhilHealth's legal sector that puzzled this committee is the agency's supreme power. Ito, Mr. President, daig nila Supreme Court. To modify, if not disregard, the final decisions made by higher courts. But hindi to. During the course of the hearing, the case of Perpetual Soccer Hospital was brought up due to the irregularity done by the PhilHealth Board by not executing the decision of the Court of Appeals, which affirmed the earlier decision of the PhilHealth Board to impose the 3-month suspension of accreditation of the said hospital and for the payment of 10,000 pesos to PhilHealth. The said act is a clear violation of the doctrine of immutability of judgments. Likewise, in so doing, it is as if PhilHealth tolerated the fraudulent act of Perpetual Soccer Hospital. And ultimately, such action of PhilHealth further caused losses from the coffers of the agency by reason of the releases the PhilHealth made to the hospital during its supposed suspension. Suspended dapat Had PhilHealth implemented the board's earlier decision, which was affirmed by the Court of Appeals, then okay sana. But it was revealed by SBP Del Rosario during the hearing that the basis of the board is changing the penalty to payment of fine amounting to 100,000 instead of the 3-month suspension and a fine of 10,000 is a board resolution allowing the conversion of decision affirmed by higher courts. Ay, maliwanag, nandun po sa record yung sinagot niya. Sabi niya, anyways, to answer your question regarding the perpetual sugar, it was a decision by the PhilHealth Board of Directors based on a policy that was decided even before I was appointed. Inuturo niya yung board. Talaga naman meron. Meron board resolution to that effect. Since the action of the board in converting decisions of higher courts was anchored on and backed by an earlier board resolution, the Perpetual Soccer Hospital case is not the first case whose decision was converted by the board, as narrated by Corporate Secretary Jonathan Mangawang on 11 August hearing of the committee. Siya mismo nagsabi noon, I quote, PhilHealth Board decision of perpetual case is not actually the first decision of the PhilHealth Board where it modified a decision of the Court of Appeals. Supreme Court. Mr. President. Although the PhilHealth Board has quasi-judicial powers, its powers are only exercisable in matters that are within its jurisdiction, particularly when the cases are still pending the agency's decision. And it does not extend when a higher court has already acquired jurisdiction over these cases. It is already well settled, as stated in the 2004 case of NHA versus Court of Appeals, that a decision that has acquired finality becomes immutable and unalterable, and may no longer be modified in any respect, even if the modification is meant to correct erroneous conclusions of fact and law, and whether it may be made by the court that rendered it or the highest court of the land. Mr. President, another issue related to the irregularities in the legal sector of PhilHealth is the diluted cases against erring PhilHealth officials. In an incident involving some employees of the PhilHealth Regional Office Region 2, were involved in an advertently depositing 9.7 million in Balanga Rural Bank, which is supposedly due to B. Brown Avitum Philippines and be deposited to its bank account, Bank. During the August 11 hearing, it was established that this blunder by the subject employees of PRO2 was solely be blamed on human error. Now, to wit, Ms. Aragona, yes, as far as I can remember, sir, yung Balanga, when it was reported to us, ang naging problema po yata isang pag-select ng bank for the transfer. So I think there was an incident report on that. Yung doon sa mismong natin na region. So I had to get the details. Pero yung po ay natatandaan ko na. So there were something na nagkaroon ng error sila doon sa pag-select. Senator Lacson, anong klaseng error? Man-made itong error na to? Hindi pwede siyang machine ang mag-error dito kasi very strict kayo sa mga online transactions. Ms. Aragona, opo. Senator Lacson, hindi pwedeng mag-crossover ng regions kasi ina-apply nga yun. However, Mr. President, despite the substantial amount involved in the infraction of the employees or the employees involved, only a simple neglect of duty was filed and meted out against them. In a similar vein, as pointed out in the committee hearings in the case of Pamela Del Rosario, which involved fraudulent claims amounting to 1.17 million with the indispensable participation of the PhilHealth employees. Based on the investigation report, Regional Special Investigation Team of PhilHealth dated May 6, submitted to then Regional Vice President Dr. Leo Douglas Cardona Jr. He recommended cases to be filed against the erring employees were dapat syndicated estafa, falsification of documents, usurpation of authority or official functions, violation of the PhilHealth law, serious dishonesty, gross neglect of duty, grave misconduct, among others. Yet, what was filed against the employees involved were just simple misconduct. When the PhilHealth resource persons were asked regarding this, none of them denied the report. Another case in point to prove the dilution of cases by PhilHealth officials is the very case of Attorney Del Rosario himself, SVP for Legal Sector. Although the case happened when he was the head of Physical Infrastructure Resource Department, as raised during the August 11 hearing, Attorney Del Rosario was charged together with one senior vice president with an administrative case of budget insertion relative to the construction of PhilHealth's corporate center. While the senior vice president was relieved from his office, Attorney Del Rosario was just found guilty of simple neglect of duty and was fined amounting to his 15-day worth salary. E pagkaganyan, Mr. President, mawiwili talaga yung mga katarantaduhan ng mga empleyado. Pagka ganun-ganun lang ginagawa natin. If the internal policy in PhilHealth is really to grant its employee impunity or impose on them penalties that are not commensurate to the violations committed, the committee is not surprised why the performance of the agency is very dismal and deplorable. It could be easily deduced that there is indeed a systemic problem in PhilHealth that has to be immediately remedied, especially that the agency plays a vital role in the delivery of the healthcare services in the country. Which brings